Hello, everybody. This is Paul de Hurt from CPDP headquarters. We are active, we are operational. Usually there's more than 1,000 people, and now we have 15 excellent people driving the technicalities of this digital conference. But I was asked to introduce this last very special panel. It's an anniversary panel, and we should celebrate it. 40 years is a lot. It is a lot of wisdom accumulated through time. And it is a kind, and this should be, and there could be, and there might be some self-confidence there, because once you turn 40, you have faced so many turbulence, you have faced so many changes, and the result is solidity. And that's what we're celebrating. We are celebrating a very dear partner, the Council of Europe, a very solid partner. When the Council of Europe, 15 years ago, decided to start having a party every year, the 28th of January, 1 year later, we followed with CPDP because we like this festivity concept. We like the idea of partying, of bringing the message in a more public way. And it was inspiring. So thank you for people of the Council of Europe for having that great idea of bringing law in the books and law in action on the street through festivities. CPDP is on every year faithfully programmed end of January. And it's because of you, Council of Europe. You showed us the way, and you created this unique idea in the midst of the winter, when everything is dark, when the sun is quasi-absent, to create a community of people reflecting and applying the same principles, disagreeing often, but agreeing on the language of the conversation, the language of data protection. So thank you, Council of Europe, thank you of having joined CPDP immediately from the start. You were one of our first public partners. We were proud when we were able to put your logo on our program, and we're as proud today of having you with this panel and these excellent speakers. Thank you. And now, Vincent, the floor is for you.
Hi, welcome to our panel. I know it's late in the day, and what a day it is. It's Data Protection Day, as I'm sure all of you are aware of by now. And why is it Data Protection Day? It's because 40 years ago to the day, the Council of Europe's Convention 108 came into being. And that, 40 years, it's a long time, and perhaps underlies the paradox when we're thinking about the treaty. And that's because it's been around for a while, and it set the ball rolling, and it set the tone for data protection, and perhaps set the tone even for the GDPR itself. But is it still relevant today? And perhaps has it reached a midlife crisis? And with me today to discuss those questions, we have Sophie Intveld, provider of many spicy quotes, and perhaps the EU Parliament's strongest privacy advocate. We have Ulrich Kelber, who is Germany's Federal Data Protection Commissioner. Fanny Hidvegi from the digital rights NGO Access Now. The UN's rapporteur to the right to privacy, Joe Kanatachi. And last but not least, we have real estate developer, come privacy advocate and driving force behind California's new privacy laws, Alistair McTaggart. Now, perhaps the best place to start, given that Germany is currently holding the presidency of the Council of Europe, is Ulrich Kelber. You're also at the coalface of enforcing privacy laws. You're a data protection authority. Is the convention relevant today?
So absolutely. Hello from Germany, to the conference and to all of you. The pioneering role of Convention 108 with regard to data protection legal framework is absolutely crucial for us. It's next to the, however, non-binding OECD privacy guidelines of 1980, the Convention was at the earliest supranational statute on data protection and privacy, at least in and for Europe. So Convention 108 was earlier than the landmark decision of the German Federal Constitutional Court, the so-called Volkszählungsurteil, which is daily business for us when we deal with our government and with politics about new directions in privacy. This Volkszählungsurteil, which was still so important for my country because it established the right to informational self-determination. And Convention 108 preceded respective European Union legal frameworks for data protection, the Directive of 1995 and GDPR of 2016. So this celebration means a lot to us. And with Convention 108 having defined important and still relevant data protection standard and principles, I think it will be a base for even the negotiations between European Union and other countries about what privacy will mean in future.
Sophie Infeld, maybe over to, can we still hear Ulrich?
Yes, I do.
Sophie, maybe over to you. You've called for a Paris-style agreement on privacy, and perhaps some would argue that that already exists in the Convention 108. What do you say to that?
Yes, and hello everybody, and also hello to the birthday boy or girl, I suppose, convention. Yes, well, I think yes and no, because Convention 108 is, of course, at the basis of a lot of other legislation and agreements and what have you, and has set the standard. At the same time, I think we also need more detailed agreements. In particular, if you see that we have ever closer cooperation with, for example, the United States, and also in the area of law enforcement and security, where we see that data protection and that cooperation, security cooperation, are diverging more and more. So we need really something to steer that. But I think also there are parts of the world that do not have, they don't even know what privacy is. It's not their prime concern, and that is exploited by other forces. If we see, for example, how, I don't know, Chinese forces coming into Africa and investing in infrastructure, and at the same time bringing all sorts of registration systems. So I think if we have something which is also visible to the public, because I think one of the problems with Convention 108 is not in the substance, but the fact that it's not visible to people. If you ask people in the street today, did you know that Convention 108 exists for 40 years, they're going to look at you with a hollow look. And that has a lot to do with the way that it's being negotiated, namely by civil servants behind closed doors. And I think there should be a public process which also gives ownership to people, very similar to the Paris Agreement. Everybody knows what the Paris Agreement is, and every part of the world has somehow bought into it. I mean, they may be more or less enthusiastic about it. They may occasionally have a 4-year break because of a president who didn't like it. But all in all, it's a kind of joint global standard, a global objective. And if we could achieve something like that, and then I would strongly recommend we do not call it Convention 108, because that's not going to mean anything to anybody. But something like that, use Convention 108 as a starting point for a big global conference on data protection and privacy protection around the world.
Mm-hmm. So a rebranding and perhaps more transparency. Yes. Fanny, is that something that you would agree with? I mean, you're involved in ensuring that data protection and privacy is enforced worldwide. How useful do you think the convention has been?
Hi, everyone. It's great to see you all. I agree that things could be improved, but first I wanted to give some positives of how we actually use the convention to respond to your question. One interesting dynamic that we see is that how we moved from the conversation on voluntary actions by companies to binding rules on data protection. Unfortunately, we are repeating this same mistake of starting with voluntary actions on many other topics, like on artificial intelligence, for instance, that should be clearly avoided, and we advocate for binding rules. So on very concrete elements of how we use the convention, First of all, I'm very proud to announce that Access Now recently joined the Council of Europe 108 committee as an observer. And this is one of our main recommendations for lawmakers and policymakers in any given country, that they should ratify the 108 and 108 plus. Our Brussels team and my friend and colleague Estelle Massé is hopefully very well known to you in these circles, but Access Now is more than just our Brussels team. And a few global examples where we use the 108 as a very important advocacy tool. One of them is Senegal, where they did a reform to their data protection law last year. And one of our key demands was the ratification of the convention. Then in 2017, Tunisia joined the convention, but we still have to continue to advocate for the full application and implementation of the treaty, as a very fresh report on Tunisia, Lebanon, and Palestine shows. I can paste the link later. In addition, maybe as a last one, in Brazil, there was a really alarming situation where we announced, and the committee, the 108 committee, to inform them that we have to denounce the clear lack of independence of the members who were appointed to the DPA, who were part of the armed forces. And of course, their expertise, to say the least, is very questionable in protecting fundamental rights.
Thank you, Fanny. So outlining there clearly some shortcomings around the world. And, you know, Joe, you have a global perspective too. Where do you see areas where the convention could perhaps improve, and where have you seen that it has actually improve the lives of people around the world?
Thank you for that. Well, certainly, as I look back over the convention and having seen it grow, 2021 marks my 37th year of being linked to the Council of Europe and the convention in various ways. So I think that firstly, I should explain how useful it has been to me in my UN role, right? If you look at what it takes to get countries to agree together, to answer the simple question, how long does it take for the UN to make a treaty? It normally takes, and we have deliberately carried out a study on this, between 17 and 27 years, right? And you can imagine that in the digital area, we don't have the time for that. So had I to go back and try to persuade people to write a new UN treaty about privacy and data protection, you know, you would need at least 3 or 4 special rapporteurs and their tenures to pass before you get a treaty. As it is, I found a working framework which today has been embraced by 55 countries to the ratifications of Convention 108, 11 countries with the ratifications of 108 plus, and 70 countries, more than 1/3 of the UN's membership, which meet in Strasbourg or online these days in order to carry out meetings of the TPD. So we have a tried and tested body of principles, which in fact is very useful. And you asked me how I see it being able to improve. Certainly, Convention 108, especially in the field of surveillance and privacy, provides tools and agreements which, for example, the GDPR does not provide. Article 9 of Convention 108, Article 11 of Convention 108 Plus provide the framework of necessity and proportionality for the use of any personal data when it comes to surveillance, when it comes to law enforcement, when it comes to national defense, when it comes to national security. And that is precisely one of the areas where I have been formally requesting the Council of Europe to take the discussion forward. Because we need, as usual, we need a more detailed discussion. The devil is in the detail. So here is where I continue my appeal to the Council of Europe to seek detailed discussions in a sectoral way on privacy and state-led surveillance, because in the same way as the Council of Europe Myself in the past, personally have contributed to discussions on data protection and medical data, data protection and insurance data, data protection and statistics. We need to tackle state-led surveillance, and the Council of Europe should be able to provide the right framework to do that within the overall framework of Convention 108. Thank you.
And zooming into the United States and California, Alistair, what's the view from there?
Well, thank you. I thought I would explain a little bit about what's happened in California the last couple of years, because it's, for those of you who aren't familiar, it's pretty interesting. So I have a presentation. I don't know if they can put it up here, but here we are. And so I thought what I would just do is talk about the existing law, which is called the California Consumer Privacy Act, and then I'd move on to the what just happened in November. So California has a process where you can gather signatures, put a law on the ballot, and if people vote for it, it becomes a law. And so in 2015, inspired by Europe, and I should say actually, first of all, what an honor it is to be here, and thank you, and you know, everything that's happening here in California, we owe a direct debt of gratitude to the European foresight 40 years ago, because we wouldn't have any of this without what happened in Europe. So thank you. Anyway, inspired by the, you know, what was happening in Europe 4 or 5 years ago, I thought I should see if I could get involved. And I put an initiative together in 16 and 17, got the signatures in 18 to put a measure on the ballot. At that point, you know, the industry went crazy. We were going to be in this big fight. And then something happened, which I didn't actually know at the beginning that could happen. The legislature gets involved, and there's a provision in California where they can kind of negotiate with me, the sponsor of the measure, and they can say, you know, if we pass this law, will you withdraw your measure? And I initially didn't think it was going to be possible, but eventually we did pass a law. And in June, 2 years ago, it passed unanimously out of both houses, which was pretty gratifying. And that's the California Consumer Privacy Act. What does it do? It's kind of GDPR light is one way to think about it. It gives you the right to know what information has been collected about you, the right to delete that information, the right to tell a company, don't sell that information to companies I've never heard of. And it gives you a right to, in the event of a negligent data breach, you can have a personal consumer right of action, a collective right of action against the company. It's called a private right of action. And so this brings me to the next law, the California Privacy Rights Act. After the success of the first one, you know, it was apparent to me that there was still room to grow. And if you thought about GDPR here, Convention 108, the principles that are here, kind of California was not there yet. And so I decided to do another initiative. This time we had to get more signatures because of the supervision of California law based on the last election. So we had, and this one I took to the ballot this November. And gratifyingly, we had you know, in an era of razor thin margins, we had a margin of over 2 million people who voted for this law. So it's now the law. And what does it do? It basically takes CCPA, the existing law, one here, and it strengthens it. And so directly importing many of the European concepts. So one of them is this notion of sensitive personal information. It gives you the right to tell a company not to use that sensitive personal information. You can stop the precise geolocation, geo-tracking, and that's a circle with a radius of about 1 kilometer. It creates a DPA, a privacy protection agency, and importantly, it funds it from the state's general fund every year, so you don't have to go back and have a political battle about whether to get funded. And this should allow for about approximately 50 employees. And I know from a European perspective, from the DPAs, that may not be the biggest number, but when you think about it, this is about 25% more people than the FTC has for the entire country in the United States. And so just quickly, in closing on in this portion, I'll just go through some other benefits that are in this new law that just passed that are not in the existing law. So we have purpose limitation, we have storage limitation, data minimization, chain of custody, so you can't transfer the information out of state and get around ours. You have reasonable security, a new right of correction, a right to object to the profiling that's directly brought in from the European language. We have the right to opt out of this cross-context behavioral advertising so people can't track you around the web. cybersecurity audits, a chief privacy auditor, and the annual risk assessments. So I'll leave it there for now. I think in round 2, I'll talk about the next steps for California. But that's the state of play right now in California. We now essentially have, in many respects, equivalence with many of the European rights. And this is going to get implemented over the next couple of years. Thank you.
Thanks, Alistair. And you mentioned equivalence there. And there's been some talk, whisperings at this stage of potentially having an adequacy decision for California, which would be perhaps not something which people would expect. You'd normally expect the United States as a whole, but what do you think about the prospects of California breaking away and having its own adequacy decision?
Well, if you forgive me, for speaking so long right now, but the second half of my little presentation, if they want to put it up, I addressed this. So the thing that, if you want to put that presentation up, but the thing about adequacy is GDPR specifically allows for a territory to be deemed adequate. So it doesn't have to be a country. And remember, we have 40 million people. We're the 5th largest economy in the world. In many respects, we're bigger than many European countries. I think it makes a lot of sense to seek adequacy. Now, it's a political decision. We understand that there are national security implications. But my sense is with the new administration, from talking to people who are expert in this area, that the Europeans and Americans will work out something on the national security angle, because pretty much everybody knows all the countries are doing it. So assuming that we now have an administration that is willing to play nicely in the sandbox, and we solve the national security issue, you still have the question of what's the adequate data protection regime. And I think that California, my hope is that now it is, because to my knowledge, there's nothing in GDPR, in CPR, the new law, that because it's there would not let adequacy be determined, and also nothing missing that because it's not there would prevent adequacy. And I think the interesting part of this I'll stop there, because we can talk about the impact of us on U.S. law, but you just asked about adequacy.
Yeah, no, I think it's an interesting topic, and I think that given that this year we'll be talking about data flows a lot, there's the potential for 3 adequacy decisions from the EU. So there's the renegotiation of the privacy shield. There's the UK adequacy decision, and potentially one for South Korea. We have the other adequacy decisions under review. Yesterday, I don't know if the other panelists saw, but Bruno Giancarelli, who's the Commission's, he's the head of data flows and data protection at the Commission, so in charge of doing these assessments. He said it was all about convergence. So, states all heading towards similar privacy standards. And I thought it was interesting to note that his counterpart, Joe Jones at the UK government, was instead calling for perhaps a more nuanced approach, looking at different cultures and saying that we need to embrace different approaches to privacy. Opening this up to the floor, but of course, if you want to continue, Alistair, then feel free. But what do the panelists think about the idea of using the convention to perhaps bring about a more multilateral approach to international data flows?
Before we go there, can I just maybe react to say that I hope that solution about national security will not be in quotation marks, because we have seen how that inadequate solutions in the past caused not only the legal uncertainty, but the case on Safe Harbor and then Privacy Shield. And we need something that truly protects and maintains the standards of the European Union for fundamental rights. And it's true that many European countries need to have their own surveillance reforms, but that should not be the basis of lowering our overall threshold together in these negotiations.
Mm-hmm. Yeah, so government access to data obviously was a topic which exploded last year with the Schrems II ruling. It's addressed quite comprehensively, I think, in the convention. But what do the other panelists think about that? Whether we're getting the balance right there with government access to data and keeping data flowing around the world?
If I may intervene on this very quickly, there's a distinct difference between what we need and what governments are prepared to discuss, right? Let's not beat around the bush. I am very clear in my mind that we need agreement about international law solutions to surveillance and jurisdiction and privacy. But governments need to change their attitude and in some cases what they're saying. Some governments have said quite clearly, including the United States, has said quite clearly they don't want binding rules. Now, I come from the school which is all in favor of international binding regulations when it comes to privacy, data protection, and surveillance. But some countries have stated their open position that diplomatically they don't want to go there. There are, as we know, no solutions unless you go there for issues such as jurisdiction, etc. So let's not beat around the bush. Convention 108 and several other actions, not only of the Council of Europe, but also of the European Union, give us avenues to explore and frameworks within which to reach agreements with several countries, not only the United States. Mm-hmm. How we deal with this is going to be a matter of realpolitik also, as we deal in other issues when it comes to privacy and surveillance. And it's a much wider subject than possibly we can handle here tonight. Thank you.
Sophie?
Yeah, so I wholeheartedly agree with that, because I'm becoming increasingly, what shall I say, worried, cynical about the gap between laws on paper and reality. We have GDPR, and Europe is patting itself on the shoulder, saying, "Look, we have the best privacy law in the world." But if we're honest, we see that national DPAs, but in particular the European Commission, are not enforcing. National authorities don't even allocate the necessary means to the DPA, and the Commission is just turning a blind eye. We also know that the whole debate about the adequacy decision on the United Kingdom is just, it's Chinese theater. How do you call this? Chinese puppet theater. It's all politics. We know that the European Commission wants to give an adequacy decision to the UK for purely political reasons, and they're going to try and talk around it and make it look as if the UK is adequate. Well, everybody knows that it isn't. And we also know that the Commission has a shitty track record when it comes to enforcing our standards in international relations. Look at how we know that the EU-US PNR agreement, for example, is a blatant violation of EU laws. That's now been established in the opinion of the ECJ on the Canada agreement. Commission doesn't care. The Commission refused to repeal Safe Harbor. The Commission refused to repeal Privacy Shield. The Commission is now going to completely ignore the fact that the UK has an agreement with the US that was concluded even before Brexit, before the actual Brexit a year ago, on e-evidence, which is, of course, it's contrary to Schrems. So this is all, none of this, and this is, I'm coming back to my initial point. Mm-hmm. And I wasn't being cynical at all about Convention 108, quite the contrary. But a legal instrument only has value if you have public opinion behind it and political will behind it, and the two are connected. If there's no, there's not going to be political will going against public opinion. So if people are attached to this, if they take ownership, then politicians will understand it's important and they will fight for it. Whereas now, privacy considerations and data protection, even if it is anchored in law, even if it's anchored in EU law, primary law and secondary law, if the political will isn't there to defend it, and if they think other considerations like international relations are taking precedence over privacy considerations, then the law isn't worth very much. Mm-hmm. And therefore, I think the buy-in from the public, taking ownership, is crucial for its success.
Mm-hmm.
So, if I may, the Commission now failed 2 times in the court with the adequacy decision, with the safe harbor and privacy law. So I expect from the Commission to be really careful about the work with the adequacy decision with the UK, and there has to be some things given by the UK side to stay on a level which is necessary for an adequacy decision, and on the long run with the adequacy decision maybe reachable with the US. And so the things which has been done in California is not only a great development for the people of California, but maybe the first step towards a national federal law, which will have the private sector side of such an adequacy decision, which wasn't that fine in the past too, because you could go under that privacy shield as a US company, but there was no one really looking if you do the things you were comply yourself. The idea of government access to data is a thing we have in all countries. So it's not a question if there is access, but the way of the access, the way which data are collected, how they are used. Is there any reason for collecting? Is there a level of protection of citizens? Or like, for example, in the US, there is a much lower level for non-US citizens in that question. This is a thing which Europe can't accept, and the European High Court give a really hard and tough decision that politics cannot even try to level the way to accept that. And this is now the framework everyone is dealing with. And also I'm doing the detail and sometimes frustrating work in the European board itself. I'm a little bit more optimistic than Congresswoman Zerfeld, because I see that the pressure on member states and the European Commission to really enforce the law in Europe, and that means opposing other countries which doesn't follow these rules for the business of their companies with European citizens, will be coming higher and higher. So time is on our side at that level, and developments like in California with Alistair is giving us some wind from the back.
Fanny?
I wanted to say 2 things. One of them is, that's a very short point. I see the UK situation similarly to what Ms. Intveld said, and it's even worse because we are judging the situation on the basis of a law and a set of laws that are already not in compliance with our standards, when we heard that these laws will be even changed. And on the enforcement side, I also fully agree, unfortunately, on the cynicism or jadedness on this front. And while we support the GDPR, we've recorded lots of enforcement failures in the past few years. The slow resolution of complaints, the increased fines, yes, but the overall number is still extremely low compared to the number of complaints filed across Europe. The very limited actions in Ireland and Luxembourg, the under-resourced data protection authorities, and their budget is completely ridiculous compared to the companies they should keep under control. Mm-hmm. And finally, I would say that the situation is even worse because these enforcement failures are now aggravated by the global health crisis, which is not just a health crisis anymore, but it's embedded in different political and human rights crises. It brought emergency legislations, abuses and political interference, and many more. And as a Hungarian, which I don't want to derail the conversation, but as much as I support the European Commission's work on many fronts, I cannot trust that body fully to enforce my fundamental rights. And that's the unfortunate situation in that political context Sophie describes.
Picking up on a point you said there, Ulrich, so enforcement's been talked about quite a lot already in Ireland and Luxembourg in particular. Will you have a word in your colleague's ear to perhaps speed up some of the cases?
So there's we're seeing some fight with my colleague from Ireland, me even in the media. So she was telling the public I don't have any experience in regulating large telecommunication companies. Even I have the regulation over the largest European telecommunication company. And on my side, I said I expect that there has to be decisions in major cross-border cases 2.5 years, more than 2.5 years after GDPR was fully in charge. And we only have seen one larger cross-border case now, and now the second one is on the floor. And we are really fighting for having a common understanding of what has to be decided in that cases. And from the moment we have decisions on major points of the enforcement of GDPR, this will also have influence on number of cases. So decision in one case will give influence on the others. But we have to have higher pressure on those which are not acting, and those close and in parallel to that work on the draft decisions on that cases. We are working on a common understanding of the Articles 60, 62, and 64. That means the cooperation. And I told my colleagues that I'm absolutely willing to use Article 66 of the GDPR. That means a national decision if there is high risk for freedom rights of European citizens, or in that time German citizens, and that means that the EDPB has to react on that national decision within 3 months. And there was one example for that. Now there's a second one on the table with the Italians and TikTok, but the first one was with the smart speakers, when we heard that they're doing some transcription work with all the things said close to the smart speakers. And so the German DPAs, we have 17 DPAs in Germany. We've told the companies that we are willing to use Article 66 to forbid that transcription in Germany. And the reaction of all that worldwide operating companies was to introduce an opt-in mechanism, because they don't want to see a written decision of the European Data Protection Board, and that shows that enforcement is possible, and we will have that pressure on the board to have decisions on the major cases.
And one of the decisions you're talking about there is, we know that the Irish Data Protection Commission has submitted a draft fine for WhatsApp around transparency issues, and they've the number that they've put is between 30 and 50 million for those violations. Do you think that's enough?
I'm not allowed to speak about such pending cases that will have a negative impact on the work, even for majorities in the board. But it's not only a question of the fine, but the question which points are addressed by the draft decision. Is it just a question of transparency, of the legal ground of collecting data? And so the first question is if the draft decision is really covering all the points which has to be decided. And the second one is which are the right actions under Article 58, which fine is one of them, and then the high of the fine itself. So there's a lot of work to do with that draft decision. We are delivering our comments on that these days. And then we will see the debate in the expert subgroups and in the plenary. The case itself started in Germany, as I think, which is now done in the draft decision. So my colleague in Hamburg and myself are really close to the topic.
Mm-hmm. Your colleague in Hamburg told me that you'd filed an objection to that decision. Could you give us any more information about what was in that objection and why you objected?
No. I'm sorry about that, but I'm a friend of transparency. You know, I'm even for freedom of information, but up to that point, that's confidential. So now the Irish, if we given an objection like Professor Kaspar said, then it's now time for the Irish to react on our objection. But normally, Professor Kaspar is very well informed.
Bringing it back to the convention, Joe, I saw that you had your hand raised.
Yes, I just wanted to add some footnotes to what Sophie and Ulrich said, right? I share a lot of what they have been saying, especially about the reality. So firstly, when we talk about the difficulties we have in Europe, let's start with Europe and then go outside. Let's just remember that if we had to ask ourselves the question, how many of the EU member states, the 27, are properly respecting Article 9 of Convention 108 or Article 11 of Convention 108 Plus, which deal with necessity and proportionality in derogations of privacy and measures which deal with national security, defense, law enforcement, etc. Then my answer is, when I look at just the national systems, forget about international agreement at this moment in time. Out of 27 member states, I doubt if there are 5 to 7 of those states which have taken seriously enough the allocation of resources for proper oversight and proper laws governing oversight insofar as surveillance by government entities. And then, if we come to the other point, which was very ably made by Sophie, please, I mean, let's not continue to make bad jokes when it comes to adequacy, right? Frankly, we are faced with a European Commission which recommended and somehow persuaded people to give adequacy to Japan. If they give adequacy to Japan, they'll give it to, you know, to some other country which is far from deserving. With all due respect, in spite of the validity of all the points raised by Sophie, the United Kingdom and its laws and its oversight mechanisms are a shining example when you compare it to Japan, which is why the Japan decision of adequacy was so dangerous. It should never have been given. It should never have been given. And instead now you're going to have countries saying, but you gave adequacy to Japan, you won't give it to me when I have superior laws and mechanisms. Now, don't get me wrong. I'm not saying that the UK position and safeguards are perfect. But what I am saying is that all decisions of adequacy given by the Commission are very important, which is why they must be properly in line with what we are expecting. The upcoming discussions between the EU and the United States are extremely important. They are extremely important because they need to set a standard. The standard established by the European Court in Schrems and other decisions, even of the European Court of Human Rights. But you cannot have two weights and two measures. You cannot expect the United States to meet one set of standards and Japan to meet another set of standards. And your own 27 countries, you're not really pressing them to meet those standards. And then you're going to have a different discussion, which, as Sophie rightly said, with the UK, with all its good points and bad points, having already got an agreement which complicates matters with the United States beforehand. I mean, you know, this is why Sophie is so right about the political will, because without the political will, and I'll come to my final point here, we need to make sure that enough resources are dedicated to educating people. Because without education, without people realizing what it takes to be a digital citizen and all the measures that they need to take to protect their own privacy with the means, technical and other means available, we cannot arrive at the point where all the people around the table would be happy enough with the situation. Thank you.
Sophie, do you want to respond to any of those points?
No, I wholeheartedly agree with the double standards argument put forward by Joe. That's absolutely true. That's something we see across the board. I would like to add, though, that with the UK, I think it's even more important.
We seem to have lost Sophie.
I can still hear Sophie.
I can hear you.
Yeah. Alistair, you had your hand raised there.
Sure. Well, I just wanted to talk a little bit about, because it came up, enforcement and then adequacy. So, one of the interesting things about what we've done in California with enforcement, so I talked about the Data Protection Authority that we create with the budget and with the new mandate to enforce the law. But kind of I guess the secret sauce is that whereas under CCPA existing law, it's just the Attorney General who enforces, and there are limited, obviously, resource constraints there. Under the new law, you'll have the DPA, and the Attorney General also has the right to enforce. And here's the key: all 58 counties in California, those are the sort of the largest geographical subdivisions, and then the 4 biggest cities also have the right to enforce the law. And for those counties, those are big entities. There are 8 counties in California, I just looked at it the other day, that have more people, are bigger than the bottom 11 states in the country. In some of these counties, LA County has 13 million people. So they have large legal infrastructures themselves. So we are counting on not just the DPA enforcing, but these counties are run by politicians. And so if you're an ambitious politician, it's a great way to make a name for yourself to help enforce privacy for your constituents. So that's one thing. I understand that enforcement everywhere is constrained, but we're hoping to get the benefit of the whole state here, the largest state in the country. Then with respect to adequacy, I think it's interesting. I understand, I see everybody's anxiety about maybe the decisions going to, political entities that were not as maybe deserving in your view. But coming from our own experience, where really in the country there's no global omnibus, privacy law in the United States, and it seemed to me that we came close to not having one. But now with California, we sort of gotten a toehold here. I think what's going to happen is one of 2 things in the United States. Either Congress will act, given they can't even agree if Biden's really president. It's hard for me to think that they're going to act on something as complicated as this, though they could. But bear in mind, if they do act, they have to do a couple things. One, California Democratic representatives in the House are 20% of the House Democratic caucus. Plus, we have the Speaker. It's hard for me to see that the United States Congress will that California will allow them to be preempted, its own law to be preempted by a national law that's weaker than California. And yet we have a private right of action around negligent data breach. It's hard for me to see the Republicans in Congress agreeing to allow anything passing with that private right of action, which is just anathema to Republicans. That strikes. So I think that we've now imposed a high standard, and if Congress is going to act, they're going to have this really high standard, which is going to be hard to handle. I think if I had to bet, I would say that it's much more likely we go the route of data breach, where California passed the first law in 2006. Congress failed to act. I think it was 2018 or so. Alabama passed. It was the 50th state to pass. And this gets me back to adequacy. What I think is interesting about adequacy, and again, it's a political decision. The Europeans can decide. We have our law now, whether or not there's adequacy, at least the law will be there. But to the extent that the Europeans did decide to grant adequacy to California, and there were a way to do it, and we do solve the national security issue, I do think that puts the pressure on other states to say, wait a second, we can't let California have this sort of international agreement. And remember, it's not a treaty, because states can't enter treaties. It's a one-way determination from the EU, which works. If you're Washington or you're Texas, you think about, well, where's Microsoft going to put a data center? They're going to do it in California. We can't let that competitive advantage accrue to just California. I think adequacy will really incent other states to act more quickly. And I think if you're Europeans, it's one thing to think about that by granting an adequacy decision, it helps move this large bloc, United States, towards higher standards for privacy. So I think it's an interesting dynamic.
Mm-hmm. Yeah, so California kind of acting as the forerunner there for a US federal privacy law. I think it would be a good opportunity to turn to some of the audience questions now. So one I picked out here from Deborah Kennedy Mayo. And she's asking, with the strict new requirements that Schrems II expects to be imposed on intelligence agencies in third countries, so third-party countries to the EU, how likely is that it will spur negotiations within the EU related to additional oversight for intelligence agencies in member states? So going back to that kind of double standards debate that we had there. Joe.
Well, that is something which I think is one of those areas where the same countries which meet in Brussels will have absolutely no problem to discuss exactly the same subject in Strasbourg, because they are all signatories of Convention 108. They all have a framework within which to carry out these discussions within Convention 108 and Convention 108 plus. So what they need to do there, and I have appealed to the Council of Europe and to the TPP to take up a serious discussion on the actions that need to be made to set the minimum standards of independent oversight authorities for secret services, intelligence services, and police in all of the EU member states, and all the states, in order so that they can have minimum standards, which would not make it worse, right? That the EU would demand certain standards of the United States which are not being met in Europe. Because then we come to discuss adequacy with California. And yes, of course, we know of the California effect, which is well recognized within US law. And that is something which, I can see myself nodding to Alistair and say, yes, let's see the California effect there. But in reality, of course, Alistair is aware, as I am, that there are complications when it comes to federal reach inside California and the problems that creates for any agreement, the adequacy. Whereas then we look at what's happening vis-a-vis the other member states. And ultimately, and I end here, we're back to the issue of political will. Do they want to have the discussion? Because we saw the political will stop discussions of this in the European Council when we had all the discussions about Snowden after 2013, and we saw some countries, including the UK, blocking the discussion inside this on the grounds of Article 4, subsection 2 of the treaty, where national security is a reserved matter. There are no such excuses to do that in Strasbourg. So let's leave of those excuses, and I would totally support any discussions within the EU member state inside the framework of Convention 108 to achieve respectable minimum standards which are in line with Schrems and in line with all the decisions of the European Court of Human Rights. Thank you.
Thank you, Joe. And here maybe a question for you, Fanny, and it's about how the convention might be better implemented in countries of the so-called global south that have already ratified it.
Well, first of all, I think that's super important to mention that the high standards we have in the European Union and the GDPR cannot serve as a basis for some kind of tech-driven colonialism, and exporting our norms is not the same as setting those high standards. And unlike these negotiations that are deeply embedded in politics and money, the Convention 108 has the chance to be that global standard and to be implemented in other countries as well. And I'm hoping, though, that these enforcement challenges that we described are also monitored very closely in those situations, because I think if we are struggling with the GDPR enforcement, well, then we are definitely struggling with the enforcement of international treaties, including this one.
Sure. And picking up on that point, there's a question here from Jeff Ausluis from the University of Amsterdam. And he's saying, time and again, it's confirmed that one of the most important issues that we talk about is proper enforcement. And it's not just because of limited resources. Time and again, we see the biggest fines being meted out on a national level, not for those cross-border cases. So what role is there for Convention 108 and for the Council of Europe specifically to help enable international enforcement? I'm not directing this at anyone in particular, but if anyone wants to take the floor, then please feel free.
So maybe from my side, as I pointed out, that Convention 108 is something like grandfather of GDPR. With regard to the future, I think that Convention 108 and later on Convention 108 Plus should continue to provide a certain level of consistency in data protection legislation in entire Europe. That means, from my point of view, trends and developments in this regard in Council of European Member States, as well as an important regional network, will need to be monitored. And from time to time, or when it appears to be necessary, the Convention will need to be amended, recommendations updated, now from 108 to 108 Plus, and it has to monitor the technical changes and developments in society. So to hold the impact and to give a ground, especially for if you try to export your ideas, to have a level playing field for your companies, to ensure the rights of your citizens to be enforced worldwide in the moment they are the partners for services and products. Then you have to be on the track with technological and political development. And so there is a kind, even not seen every day, but there is a kind of parallel development between enforcement of GDPR and the development of Convention 108, and especially if we see maybe in future some more non-European countries as signatory parties. Maybe someday Canada or India and even the United States, then this impact will even be higher. And the pressure that the reality in the board is that which is written down in the legislation will be higher than it is today.
Mm-hmm. Okay. Thank you, Ulrich. There's a question here, and perhaps we have been quite negative on this panel, and there's a question here to perhaps look at the positive side and look at the most far-reaching and new provisions in the modernized Convention 108 Plus. So, are there any provisions in the updated convention which have really struck any of you as being particularly cutting edge or helpful for privacy and data protection? Sophie.
Well, I think this addition or extension, whatever you want to call it, to include national security is, I think, quite important. Because so far there's kind of an understanding that normal privacy or data protection rules don't apply in that area, which is of course not true, not even under GDPR or e-privacy, but it's very helpful to make that more explicit, because I actually think that if you say we are negative, I'm not negative. All I see is that there are, we have passed laws, convention, GDPR, whatever, but we see that governments always find ways, interpretations, to make a carve out for this area of national security and law enforcement and other public policies they consider to be important. That's the whole problem. And if I may also, responding to something that was said earlier about standards and exporting standards, it's not just about standards. It's not just about everybody, let's say everybody all around the world would adopt the standards of Convention 108. It's not going to do the trick all by itself. You have to see these things in context. What kind of relations are there between countries? As I said, the relations between the EU and the UK are going to be different than the relations between EU and Japan. So therefore, the level of protection needs to be different. With regard to the US, for example, the US does have a very elaborate corpus of data protection rules, even if it's a bit more scattered than in the EU. There have also been transatlantic agreements to protect citizens' rights. But the difference there is it's not so much the standards in the US itself, it's the fact that they don't apply the same standards to US citizens and other citizens. So everything depends on the context. And therefore, I think this addition of national security is very, very important.
Mm-hmm. Fanny, you raised your hand.
Yes, I will not mention a specific article, but I want to say something new, because the Council of Europe literally just today published new guidelines on facial recognition that in many ways connect some of these dots that we're talking about. And these new guidelines are not too bad, but they could definitely go beyond what they say. They prohibit affect recognition completely. They recognize the human rights violations can be caused by live facial recognition, but they only call for a moratorium and not for a ban, which in our view in that situation is not enough, because those type of violations are non-mitigable and they are inherently in conflict with the fundamental rights. And so I think the European Commission and the Council of Europe as well have the option now to take next steps and not just address old, let's say, surveillance questions that are unfortunately still on the table, from data retention through the PNR that we discussed. So it's not just the national governments that have a terrible record, but the European Commission and the European institutions as well. We are hoping to see binding rules on the use of facial recognition in mass, but facial recognition that enable mass surveillance that is clearly unlawful under European human rights law.
So those facial recognition guidelines that came into effect today, and in the Commission's AI strategy, they also in initial drafts they suggested a moratorium, and eventually it was dropped from the final version. What do the panelists think about a ban on facial recognition? Is that the way forward? Ulrich.
Yeah, maybe Alistair first. Yeah.
I think it's a very fraught topic here right now in this country, especially with the inaccuracies of so much facial recognition. The documented inaccuracies racially and sort of the what that might contribute to in terms of a surveillance society. Personally, one of the things that inspired me to get into this, I remember one time thinking, my goodness, imagine where we're headed, where you're going to be able to put on your Google Glass or whatever, eyewear it is, and walk down the street and essentially know basically everything about everybody you see, where they live, how many kids they have, what their mortgage is, you'll be able to extrapolate, how much money they have. And I just thought that's just a terrible world. And so I obviously, national security folks are going to really want to use it because it's very, from their perspective, useful. But I think it's an unbelievably dangerous technology that, if it is used, has to be used very, very thoughtfully.
Okay.
So all kind of biometrical analysis, so face recognition, but recognition of the way you move, the way you look, the way you react on things, is a high-risk algorithm. And from the German discussion, the federal government had an data ethics commission. I was a member of that, and we recommend them to have a kind of a risk pyramid of algorithms. So that means that all the algorithms, as a covering idiom for all kinds of artificial intelligence, big data analysis, and other stuff. The greatest part of that is still free market, introducing and working, and you just have that kind of post-regulation by supervisory authorities. But then there are steps of that you have to show that you introduce algorithms by a kind of qualified process up to algorithms which has to be inspected in advance, or even because the risk of that algorithms is too high, with a moratorium or a long-term moratorium for them. And all kind of biometrical analyses are one of those highest risk steps in that pyramid. And the government accepted that idea, and that should be the background for their work in the European working groups. I hope they also do that if the doors are closed.
Mm-hmm. Sophie, any thoughts?
I'm not sure that I'm in favor of a ban. It sounds a little bit like, predicting what the future will look like, and maybe also, and I also don't believe that bans work. Wherever you ban something, there will be a clandestine trade. Secondly, it's already being used illegally, even without a legal base. Police forces around Europe are using it. So I believe more in regulating it. I would be in favor of a moratorium, at least using facial recognition for law enforcement and security purposes, so that we will have some time to look at it. Even though, if you see the speed at which these things are developing, you don't know if time helps. But I think some time to think and to see how we can again find some, as they did 40 years ago, some principles that we can apply and which may protect us in practice, ban certain uses. But again, it will only help if governments in Europe, in the US, around the world are going to accept the fact that data protection and privacy protection, and which is basically a term that covers a lot more, protecting people from the use of this data. If that also applies, in particular applies to security and law enforcement, I think that is the big gap at the moment. We have, GDPR convention. It will protect us against, I don't know, Facebook, Google, or any other user. But this is the big and growing gap. This is where people are not protected. We're talking about protection of people, and I don't think we need a ban to protect them, but we need to expand the area where the protections apply.
Mm-hmm. Joe, you had your hand raised.
Yes, because I think that the answer to your question, should we have a ban? I think the answer is there already in Convention 108, and particularly amongst other places in Article 9 and Article 11, which is, I'm with Sophie in saying, no, I'm not for a ban. Why? Because if facial recognition is necessary and proportionate in a democratic society, in certain instances, then do as Convention 108 says, provide for it by law with very clear very clear instances when, where, how it should be used and by whom, and then I would be accepted. But let's remember the tests. It's not nice to have. It must have. Without it, I can't operate. It must be proportionate. It can't be a disproportionate measure. It must be proportionate. And then in a democratic society. Can we please not forget those words in a democratic societies? There are already societies which call themselves democratic or not, where they put up as many cameras as they like on lampposts and disguise the lampposts, and today boast that they have more cameras than London, fine, and they're using face recognition, etc. But those are not democracies, and those are not our standards in the free world, right? So our standards are necessary and proportionate in a democratic society. If facial recognition, if and when and where it meets those standards, it's fine by me. If it doesn't, then the answer is clear. Thank you.
And last 2 minutes, Fanny, I know you wanted to say something.
Yeah, just exactly. That's a reason to call for, we call it politically a ban, but it can mean many practical things. That exactly there are situations when by no means it can justify and meet those standards. And that's why for those uses, we don't believe any safeguard can mitigate the harms and violations. And those are the areas where we call for a ban. And I would like to also mention that unfortunately our human rights legal regime is not perfect, and it is more or less protective of individual rights, but societal harms are not easily addressed by the structure that Joe described, which we obviously support otherwise. But there are areas where this won't work. And we need political statements, we need court decisions, we need different commitments, legal and otherwise, to make sure that some of the technology is not further rolled out, and many people and communities will not be disproportionately impacted by their negative effect.
Mm-hmm. Sophie, do you want a quick word? I think we're almost out of time, but
just
go
very,
for it.
very rapidly. This is exactly why it is so important that the public takes ownership, because they very often believe, they are told, if you accept this violation of your privacy or that violation, you'll be safer, healthier, protected against terrorism, child rapists, what have you. But I think people need to start and understand that their privacy is a value. It's not just second-rate fundamental right, but it also protects society. Think Cambridge Analytica and democracy. But only if the public supports this, if they realize how important privacy is, we will have sufficient push to achieve the things that you say.
So people need to take ownership. I think that's a good message to end on. I'd like to thank all the panelists. I've been Vincent Manencourt. I'm a reporter at Politico Tech. And thank you to CPDP for the conference. Thank you very much, guys.
Bye-bye.